Good afternoon, one and all. How many of you think that I am standing between you and lunch? So you will have to excuse me for 20 minutes and then we will engage in the discussion. After Sir spoke about structuralism in terms of separation of powers and division of powers, when we study the Constitution, we have a normal tendency to look at fundamental rights and remedies for the violation of these rights in the form of writs, as Ambedkar said, the soul of the Constitution, and what follows after that as distinct parts of the Constitution. Now, just like how he said about structuralism in terms of the way in which the statecraft in Indian context is theorized, in terms of constitutions, understanding also the structure of the Constitution also becomes an area where the role of these constitutional provisions play in the governance of the country, in terms of division of these powers between individuals or citizens and the state. State as an entity which is the one which is wielding actual power, but people as or citizens as generally it's not citizens, it's people, because that's what the preamble says. People as the entity which has highest power under the Constitution. So this is exactly where we see that fundamental rights have very clearly laid out list of rights, and within those rights Dr. Bhatt himself has written a book on hierarchy of rights. It's about interpretation of part 3, where in the hierarchy of rights, how certain rights are having supremacy over other rights. I would say that it is not hierarchy alone, it's also interrelationship. One cannot have a meaningful life unless they have freedoms. So Article 19 vis-a-vis life and right to life as the most sacrosanct. Now, when we are looking at directive principles of state policy, as you would have studied in your constitutional law lessons, the relevance emerges from the fact that time and again, whether directive principles of state policy are just aspirations. Are they really of any relevance is one set of question. Another set of question is where judges have emphasized in certain case laws that they are to be taken seriously, and if they are in conflict, there was a set of judgments until a certain period of time. It's very interesting if you note those periods of time also, where they said that directive principles of state policy cannot be superior to fundamental rights. If there's a conflict between the two, part 3 prevails over part 4. So the overlapping between the two and complementarity of the two was one. But subsequent judgments, they have clearly looked at the crucial role that is played by part 4. Or without referring to part 4, the spirit of part 4 has guided the outcome of judicial decisions in recent years, and which have led to implementation of policies by the state, new legislations by the state, and special approaches to certain issues. So my argument is that in governing the country, in terms of governing the country according to the compliance with the constitutional provisions, directive principles of state policy as part 4 have played a crucial role. Now quickly I'll take you through the next part if you are okay. He said that Dr. Ambedkar, the head of the Constitutional Drafting Committee, was the one who played a very crucial role. In fact, it is H.M.C. Roy, one of the constitutional jurists, who says that if you remove them also, it doesn't make any difference. But Ambedkar had feelings for this provision. He was emotionally engaged with this because after drafting the fundamental rights part, he came out with certain rights. I'll tell you during the course of my presentation, particularly rights of the minorities. It was the Constituent Assembly which said you need not cram everything into the Constitution. Let the democratic practice give us the chance, and during that practice whatever is relevant from time to time be the source of the or core of the legislation. So they left the lawmaking freedom, lawmaking power in the governments that were going to come, rather than prevailing over the governments being the first point of history at the time of drafting the Constitution, cramming it with all these details. So this is how you will see the debates between Munshi, Ambedkar. So all of you, whenever you are having recourse to any constitutional provision, do go through the debates, because they will show you at a particular time frame how the provision has been drafted and how our living experience as a democracy forced certain changes into it, and amendments are examples of that. But then is it the empirical reality of the citizens or the people which has prompted these changes, or the political interest or vested interest of the parties which have informed those changes? Is it the politics or is it the rule of law? These questions will prevail. So ask those critical questions whenever you are revisiting any question related to constitutionality and constitutionalism and within the constitution. So he says these are the principles which have one thing in the core: strive to promote the welfare of the people by securing and protecting a just social order. So justice is in the core, and social justice is in the core, is what we see in terms of overview of this part 4. But it is not just social justice alone. I'll take you through these provisions and the structure of these provisions. Now, the concern while taking this part 4 into the constitution and then calling it as a directive principle of state policy, the 4 key words, it was some of the challenges at that time which were and some of the best practices at that time which were prompting the inclusion of this. What was the challenge? After the World War I, when the world was evolving into democratic forms of government in many European countries and elsewhere, they were looking at this set of principles, particularly in Ireland, and Ireland copied Spain actually. So they were looking at borrowing this concept or incorporating this concept to see that the constitution satisfies the aspiration of all the people and lays the foundation of a society which is equitable, and it is a welfare state. It aims at the welfare of all people. And there was also a very important thing that was happening. We know that even in the British India, private entrepreneurs, the capital, was already making its impact. Like Tatas were existing then, Birlas were existing then, some of them sponsored the freedom movement as well. And they had a very love-hate kind of relationship with the colonial powers as well. So that was on the one side. And large number of people, because of the colonial past also, being suppressed, being not addressed, inequity prevailing in the society, and not legislations rather serving the interest of the colonial master than the people. So this reality prevailed. So they needed to take care of regulating, if not eliminating, the private enterprise, and then also looking at public sector, looking at protection of the rest of the people in the country. So instead of or in regulating this monopoly of powerful corporations and private enterprises, they had to have certain checks and balances. So these checks and balances could not be direct, because you needed those monopolies to at least not to disturb the apple cart, which was providing jobs, which was generating income, which was bringing revenue to the country. But at the same time, it could not be dumb or deaf to the process which was going on. So state cannot be a watchdog. It has to make interventions. So these principles were the reminders. They were setting that agenda for the future in a democratic country. Therefore, socialist pattern of society was in its view, not the ism, as Sir said. It was not the ism which was informing the socialism or communism. It was rather socialistic pattern of society, equitable kind of society. Therefore, we borrowed it from Ireland, whereas Ireland borrowed it from Spain. Now, one of the specialists said, one of the experts during the Constituent Assembly said that it's a veritable dustbin of sentiments. Sentiments among some of the constitution makers, and Ambedkar was supposed to be a very angry, emotional kind of advocate, passionate advocate of a just social order, because of his own experience and his grassroots witnessing of these exclusions of the people. Or is it just a moral right? Or is it just a regulation of private monopoly or even state monopoly? See, now private enterprises was there, colonial master was there. Power was in these two strong hands and rest of them were powerless. Now they are quickly being replaced. Colonial masters are quickly being replaced by this democratic state. Now, don't we need to regulate that state also? We cannot indirectly regulate it as the control of the military, police and things like that, but by reminders. Therefore, are they just reminders? Are they just moral precepts, or are they justiciable rights? Answer is they are not justiciable because nobody can force the state. What does that mean? Does that mean that part 4 is when it is non-justiciable, means none of us as citizens, unlike in case of part 3, can approach the court of law to make the state work for us? No. It assumes that state has the power. It wants to protect the power of the state because you are evolving into a new kind of governance. But it also assumes that the state will be run by such responsible people who will be pulsating or responsive to the reality of the society, and their policies will be friendly to the people. But the reverse is happening in many cases, or if not the converse is happening, this assumption has been upheld also by many people. So political analysis, if you see, of the post-colonial governance that we have had two types of governments. One type of governance, I would say. The same government might have indulged in two types of governance during their tenure. One type of governance is where there is a strong state and they impose top-down kind of governance. Another type of governance is where there is people from the grassroots informing the sense of governance and that informing the approach of the governance. We have had the same Mrs. Gandhi administration showing the top-down approach and bottom-up approach. We had coalition government, the Rainbow Coalition which we had in between, which was having communists with the ruling group, and it was showing people's experience being brought into, and a lot of activist approach rather than problem-solving approach when it comes to issues like nuclear energy. So we have had these kinds of approaches. So directive principles of state policy can act as a check, or it can act as a kind of informing the moral sense, informing the conscience of governance, depending on the type of governance that is adopted by the government. So whenever governance went strong, irrespective of or independent of people's aspiration, courts came in. Courts interpreted fundamental rights in such a way that what was not explicitly there in the fundamental rights structure, but would have said about unenumerated rights. Like, for example, look at the expansion of Article 21 in the judicial construction, in the judicial activism, in the judicial interpretation. Now, where is the material coming from for judiciary? What was meant to be state's directive was taken by state's arms directive in the form of judicial wisdom, coming in and infusing life into those provisions. And you would agree with me that expansion of Article 21 most of the time has been from directive principles of state policy. Therefore, it is one Article 21 which could expand into so many legislations and also amendments. 21A, for example, right to education. Where is the right to education dimension hidden? It is hidden here. When it comes to right to health and interpretation in terms of right to mental health, expanding the concept of right to health, and interpretation of special provisions for women and children, where is it coming from? It's set in the fundamental rights, all right, but in the governance of the country, when the state or the governing clique was not acting in consonance with the constitution to readjust the balance of social justice, economic justice and political justice, courts, as the custodians of the constitution, took refuge under directive principles of state policy. Now, this is something that constitutional authors will not tell you. You will have to have this critical review coming from the study of political science, humanities, social science, sociology, and empirical understanding. So, I will show you some of the examples as I move forward. Therefore, just to understand where are these directive principles of state policy, they are stretched from Article 36 to 51, and in Article Section 45 of Irish Constitution, directive principles of, they didn't say state policy, they said social policy. See the difference between us and the Irish. India wanted a strong state because India was a divided country. Even when the constitution came, we still had Nizamat in action. We had state of Goa being used as a territory of right to passage by the Portuguese. So in such a situation, they had to put it in terms of state policy, whereas in Irish context it was social policy. If you look at the constitution of China, in national defense, in diplomacy, national economy, education, etc., as well as national minorities in the frontier region, these are echoing the social policy sentiments, socialist sentiments. And Burma also contains principles of state policy. So in a way, state policy areas, are they just instructions to the state or directive to the state, or are they monopoly of the state? Here they are more of monopoly of the state in Burma or in China because they are strong states. They are socialist states in the sense of communist state where the state and the law are the engines which are driving the governance. Whereas in our case it is not that kind of a centralized state, it's a democratic state. Irish is a democratic state, so they used it as social policy, whereas we spoke of it as state policy, but most of the directives there are aiming at social justice. So they were named state policy, but they echoed the concerns, ethos of social justice. So this is the way we have to see how we have been very, very innovative. We borrowed from everywhere, we took inspiration from everyone, but we indigenized it. That is the most important observation that one can make. Now, even if state is functioning within the framework of this constitution, which lays down division of power, which defines who are the servants of the state and things like that, it must also secure national independence. It has to secure equality, international cooperation, well-being, economic prosperity. The past of the state in terms of regulation needs to also to be remembered when it is going for the future in terms of autonomous democratic entity. So what kind of state service should come about there is defined here. So this is like a reminder. It is like, it's like a vanguard of values when the state is functioning under the new constitution. So if you look at the Indian Constitution's directive principles of state policy and Article 45, actually Section 45 of the Irish Constitution, it says that principles are intended for general guidance of the oireachtas, that is Irish word for the state. And the application in the making of the law shall be the case of oireachtas exclusively and shall not be cognizable anymore. So non-justiciability of directive principles of state policy in India is very similar to directive principles of social policy in Ireland. And it is not just a verbiage, because subsequently in Indian Constitution in Article 37, it says that it is not enforceable by the court, but principles are nevertheless fundamental to the governance of the country, and it shall be the duty of the state to apply. Therefore, duty of the state to apply in the governance of the country. Article 37's spirit is to be remembered by the state, but state in the practical sense, in empirical sense, in the actual sense, they always say political exigency. Sometimes it justifies violation of the law or indifference to the law or ignoring the law. This has happened in international law case also. So some similar behavior whenever it is exhibited by the state, it is then that citizens through the recourse of the fundamental rights go to the court. Now at the end, what conclusion or inference I draw is that it was something that was echoed by some of the jurists as well as judges, that fundamental rights are the tools or means to achieve the ideals of directive principles of state policy. So you cannot view them as two disparate entities. They are neatly overlapping and strongly connected in terms of their philosophy and ethos. So framers of the constitution and critics of the constitutional law, they talk like experts like Sirwal, who said that there will be no effect if you struck down directive principles of state policy. Is that true? Because fundamental rights in a way are echoing directive principles of state policy, but they are not justiciable. Directive principles of state policy are not to be enforced by any citizen. But does that mean that striking them down will not make any difference? Not really, because the state has to take recourse to those principles. So if someone strikes down, I feel Siroy's view is a realist view in terms of court-based realism or court-based functionalism. It's not the realistic view in terms of larger idea of the state. State is not just the court, and state is not functioning only at the reminders of the court. State has got a larger operational role through its executive and legislature. So those executives and legislatures, when they make the law, when they implement the law, they definitely follow. It is there in the back of the mind. It's like a pulse ticking in the ruling group. Now, B.N. Rao, Ambedkar, Iyer and Shah, they were the ones who defended the inclusion of directive principles of state policy. Although they had different views about the intensity, and they distinguished the justiciable and non-justiciable rights. And then they also said that sometimes they could invade the individual right for a greater goal. You understand the ethos behind directive principles of state policy? These are aiming at greater common good, what Bentham said. So there is a utilitarian value. Therefore, he was a strong proponent. Venegal Narsingh Rao was a strong proponent of directive principles. Ambedkar and K.T. Shah were also the directive principles. They did not agree that these are moral precepts, but they must also be justiciable. But that was not allowed. When certain of those rights were to be included, that was not allowed. But what we see today is what the opponents of this said, that let the future governments decide through actual legislations, whether an issue which Ambedkar wanted, like he said about minority rights, let it be coming out, or civil rights, for example. For example, he includes Article 17, untouchability as an offense. But saying it in the Constitution does not give it the tooth to punish those who practice untouchability. So you had to legislate separately. Atrocities Act. Prior to that, we had a Protection of Civil Rights Act. So different avatars of these legislations came with the governments of the country feeding more experiences to the legislature and popular need informing the sense of legislature. So that is the living of the Constitution. So the ideology of socialism was strongly supported, and the nationalization of the land, nationalization of the key industry, state monopoly on the insurance, these are some of the ideas which Ambedkar brought. But the problem there was trade operates on a different logic. A kind of healthy competition is necessary, a kind of healthy opportunity is necessary, otherwise it will go in conflict with Article 19, 1G, right? So you have to balance these different competing rights as well. So Assembly rejected it, it said that let's go for the legislation. So Ambedkar then started putting weight behind this directive principles of state policy. So many of them also converted their belief that there is a need for such principles to guide the state in its governance. Therefore, they will have to be there so that the legislative power of the state is not exercised arbitrarily. Whenever you are legislating, prioritize in the line of these principles. And then they are, I mean, it was T.T. Krishnamachari who said that it's a veritable dustbin of sentiment. He was the strong dissident. Some of the dissidents converted during the Constituent Assembly debate, but he held on to his views. However, finally we had the Part 4 seeing its reality in the Constitution. Now let's quickly go through the articles. Article 36 refers to state as the same as it is under Article 12. So everybody is supposed to keep these principles in view. How many of our universities keep this in view? Or how many of the other entities which are taking the color of the state because they are coming into existence under legislation of a state are informed? Probably popularizing fundamental duties, popularizing Part 4 is one part of legal literacy or constitutional literacy that's required. Application of the principles, as we already told, they are non-justiciable. Then 38 authorizes the state to secure a social order for the promotion of the welfare. So that is the objective. Preamble to this part is in Article 38. Certain principles of policies to be followed by the state: equal justice and free legal aid, 39A. Look at that. We have the state legal aid, our Legal Services Authorities Act. And then we had organization of village panchayats, decentralization and delegation. Then we have right to work, education and public assistance in certain cases. Some of these principles, most of these principles are socio-economic and cultural rights under the Covenant 2 of the United Nations Human Rights Covenants. And we had one, I can say, part there. If you read Socio-Economic and Cultural Rights Covenant, Covenant 2 of the Human Rights Covenant, UN Human Rights Covenant, it begins with the preamble where it says for developing countries, there can be progressive realization of these rights. So this covenant came in 1955-56. And at that time our constitution was a nascent constitution. It pre-existed. Our constitution pre-existed that covenant. When our constitution came, we had United Nations Declaration of Human Rights. It was only a declaration. This covenant was an agreement where states took upon themselves the duty to follow these covenants. But in that covenant, because of the negotiation by newly emerging colonial states and poor countries, developing countries, they said socio-economic and cultural rights can be progressively realized. Isn't it the time for us to realize it by bringing some of them to fundamental rights? For example, something like legal aid, something like delegated legislation, right to work, education and public assistance. Now, if we had right to work as fundamental right, what a difference COVID migration would have seen. So, this is exactly where we see that directive principles of state policy need to be again and again referred as core of serious legislation. Although most parts have been covered in legislation and policies, some of them are still blinded by our progressive realization excuse given under the United Nations Convention. So it has the potential to make our state not only welfare state, but what Prime Minister Modi says, Sabka Vikas, Sabke Saath. If that has to happen, equal welfare with equal development in the comprehensive sense, then one needs to look at directive principles of state policy as a kind of gospel truth to be reviewed again and again. It should become our mantra in our state governance. Now, come down, just in humane conditions of work and maternity leaves. Our current government has taken certain emphatic approach to these. If you have seen maternity leave provision, it has improved a lot. For example, there is a student who is married, a lady, she goes the family way in the middle of the studies of, let us say, PhD, then she should not be coming under general rule. That period should be considered as a period of maternity and she should continue, her days should be considered as day one, as if those 2 years or 1 year she is taking for family care is excluded. So that's a kind of private patriarchy being nullified or neutralized by public policies. But is it only maternity which is woman's role? When they drafted it in 1950s, it was like that. Today, woman is a caregiver in many roles, or she might have prioritized caregiving because of her certain skills or social compulsions. Then, whether all caregivers can be protected? Can it be expanded to such legislation? Can our taxation policy be reviewed in terms of this, where her labor at home is added to the national capital and then she is passed on that taxation concession or her husband is given that kind of tax exemption for the labor that she puts in the house. So this is a family-friendly taxation policy which many advanced countries are looking at. So if Ireland has that. So if you are looking at Ireland for principles, look at also how Ireland is operationalizing these principles in its governance of the state. We could not do that because we are a developing country compared to European countries. But today is a time for us to look at it, at least in some sectors, where people are contributing through their organization, personal provident fund, public provident fund, etc. Or states, the social welfare needs to be strong. In our country, the social welfare is associated. For example, if you need a pension or if you need old age care, it's associated with the concept if you are working or not. Means a wage-based work. It should be de-linked from the work, and every young person, every infirm person, aged person, unemployed youth, they all should be within the fold of social security ideally. Now, if a state can provide for a huge parliamentary overhaul with thousands of crores of rupees, is it difficult to invest it on young people, or is it difficult to invest it on the infirm and the aged? Can you be human indifferent in your governance? So I am putting before you certain questions and I am going through this. Therefore, that time they said about living wage. Now, fixation of the wage in consonance with the living index happens to central government employees. Sometimes if state governments are willing to follow that logic, it happens. But does it happen with the private enterprise? Is private enterprise reprimanded for not complying with it? Is the state shutting its eye and watching it like a wise old owl? So these are the questions that are asked. And participation of workers in the management of industry, we have worker representation on the board, but not with the gig economy. The new IT economy has thrown the labor law outside the door. There hasn't been any correlation between WTO, which was recommending this kind of open work environment, and ILO. ILO did not endorse this. ILO was not even consulted. So COVID has opened our eyes to such cleavages or divisions between these various international regimes. And before we could think, private companies, big data companies and others have come to our country, and even in European countries, they simply give a pink slip overnight without thinking about your right to livelihood and the shocks it sends to the family, the trauma that it creates. So this is exactly 43A. In promoting cooperative societies, we have this Cooperative Societies Act and other regimes. Uniform Civil Code, most controversial one, and made the political bargain chip in the current incumbency. And Supreme Court being approached on the gendered dimension of Uniform Civil Code. The gender dimension has become a very good political gain. It has brought to the ruling party as well, despite its other agenda. So this is one area where directive principles of state policy have been taken seriously and smartly by the political incumbencies. Then in rejecting Uniform Civil Code also politics was played. In using it also politics has been played. So this is exactly our problem, when the policy is being taken for political interest. Now, early childhood care and education, nowadays with the midday meal and I'm showing you those policies. And promotion of educational interest of SC/ST, we have the reservation policy. But only reservation. What about other affirmative action in upliftment of their competencies, their health side, nutritional side? That's not done very much. We have private development corporations, etc. We need to have reviews of these and state to raise the level of nutrition, which is consonant with that. Public health situation was deplorable during COVID too. And then the Organization of Agriculture and Animal Husbandry. So, and then we talk about improving the environment, protection of monuments and places, separation of judiciary from executive. So, separation of power doctrine comes from here, and then promotion of international peace and security. If you go back to the basic structure doctrine, how many of these principles make present state? Article 50 is clearly visible there. And then this international peace and security as an internationalization dimension is visible there in diplomacy. So more or less the Chinese and Burmese approach is echoed here, but in a very gentle nudge to the state, rather than as compelling over there, because they are not democratic. But what we are saying is, if you go deep into that, three questions you have to ask. How many policies have been made in this line? Which year they were made, and are they in tune with the current globalized, liberalized, corporatized India? Third question you have to ask is, how many of them have been incorporated because of judiciary? And finally, the policies and legislations and amendments have come into part 3. If you see, as on today, other than aspirational international peace and security and the social security related aspects, most of them are figuring in the fundamental rights. Even right to work has come in Rozgar Yojana and others, although in a very diluted version than overhaul of the policy. Now the whole labor code which is coming up is in a way this directive principles of state policy speaking loudly through the government. So if you look at the classification of directive principles of state policy, there are Gandhian principles which are something like protecting the environment, animals, or even decentralization, Gram Panchayat and things like that. Then liberal principles which have some overlap like Uniform Civil Code. Then socialist principles, which is about right to work and minding the poor and all of that, and women and children and things like that. So if you look at the significance, it's not an indigenous one, you know from where it has come. The 4 vocabulary which is used there, directive, principle, state, policy. So it's a kind of guideline to the state, and they have to be taken into consideration before any law is enacted, that whether state can enact this law. And citizen cannot compel the state to follow these principles on their own. Why citizen cannot compel? Because the assumption is that state is so responsible. A state is having so much power, but at the same time with power comes responsibility. But if the state fails to follow these directive principles of state policy, in a democratic country like ours, we show them the lesson through our voting. But we are not a very literate electorate, Our electorate is also very uneven. Proper information outflow is not there. Social media access through WhatsApp and all is done by those who have the power of technology. So there are so many inequalities and gaps which are existing. In the reality of that, how far people are aware of where the state is going also is an issue. Now, if we take through the characteristics of that, some of the scholars like Devidas, who was my teacher and Professor Bhatt's teacher, he is to say that one characteristic that they are embodied in the Constitution. They are part of the Constitution. They are mandatory obligations. Means they cast a duty upon the state, not on the. See, fundamental rights cast a duty upon the state vis-a-vis the individual. These cast a duty upon the state vis-a-vis the Constitution. They may not cast against citizens, but they do cast against the Constitution. So ultimately, Constitution is drawing its power from who? From people. So finally, people have a power on this, but it's not a direct enforceable power. That's all. We don't intervene through the court. Secondly, they cannot be altered by. They can be altered only by a constitutional amendment. We have the 39A, which we saw. And thirdly, they confer power to state to legislatively formulate the restriction on Part 3. So they have the power to give the power to the state to legislate, to make laws which may restrict the fundamental rights. Otherwise, the minute any new law is formed and if it restricts fundamental right, all of us can approach the court of law. Any of us can approach. But these principles are the ones which can be justifying states such action. That is where the danger comes in. But it is clearly said by the courts. Wherever there is a conflict between Part 4 and Part 3 prevails. That means even if they have the lawmaking power, to the extent of restricting fundamental rights, if they happen to restrict the fundamental rights in the findings of the judiciary, which is the custodian of the Constitution, then judiciary can say it can readjust the balances. Look at the beauty in the Constitution. Checks, balances, further checks. So that is what you see here. Now, so these are more or less, although they are borrowed, they are humanitarian principles, they are sort of values, constitutional values, and they are the aid to implement, in fact, fundamental rights are the aid to implement the ethos of Part 4, and they are complementary to fundamental rights. And then in a number of cases that whenever a legislation is violating the basic structure of the Constitution, then the court can intervene and see that such a law is struck down. Now, there the idea of basic structure of the Constitution also borrows from this directive principles of state policy. This is what you have to remember. Therefore, directive principles of state policy are not as undervalued as it may seem. Your holistic understanding of relevance of directive principles of state policy today, when we discuss here, I'm sure it would be giving you new lights and new insights that they are not as powerless as they seem to be in the Constitution. They have the power even to check the state's power whenever it erodes through its legislative capacity the fundamental rights. So, the content of the fundamental right also is not a fixed content, as they said in Keshwan and the Bharati case, in which the basic structure doctrine was propounded. The moral claims embodied in the Part 4 cannot be taken as the basis. So, this is something that we see. So, quickly passing to the further part of the discussion, that compatibility with the fundamental rights regarding in the Part 3 and fundamental rights being enforced through the rates cannot be the one which is there in case of Part 4. This is something which is revealed, and the difference between the two is that fundamental rights are a limitation on the powers of the state. All of us have that power, having our fundamental rights, so it casts duties on the state, whereas directive principle of state policy is an instruction to the government. We don't come there as citizens. And then, secondly, anything can be violated either by individuals or the state. Of course, unless there is legislation, nobody will ask us why we did not follow Uniform Civil Code. Can anybody say that? No. We have Special Marriages Act, which provides us an opportunity to register our marriage if we are marrying between religions, or even if we marry in our own religion, we have a provision for registration. Section 9, I think. But if we don't use that legislation at all, no one is going to challenge it. Indian Succession Act, if I want to follow that, then I can follow. If I don't want to follow and I want to follow Hindu Succession Act, nobody can challenge me. So we follow according to our advantage. So if secularism was such an important principle in terms of following Uniform Civil Code, then if any one of us not following should have attracted punishment. That's not there. Therefore, what it means is that these principles can be violated, but then if fundamental rights are violated, then there are strict remedies through the writs. And any action against DPSP cannot be declared as void by the courts, but in case of fundamental rights, such action of the state can be declared as void. That legislation can be declared as null and void or struck down. So here what we see is that expansive understanding of right to life and liberty being infused into Article 21 by the judiciary in terms of certain unenumerated rights, like right to life of the unborn, right to clean environment and then clean drinking water, then sanitized water, potable water. A lot of new decisions have come in the Supreme Court. And when you go further, right to life also includes right to livelihood. Therefore, encroachment of your land in the name of big projects is not acceptable unless, even though right to property is taken away. But if that property is connected with your livelihood, like in case of indigenous people, then state has to take utmost precaution. That's what Narmada Bachao Andolan said. And it led to new approaches to Land Acquisition Act. So this is the way in which courts have fed the part 4 into part 3, and most of the right to life adjudication is reflective of how fundamental rights have been enriched by infusing of the directive principle of state policy through judicial interpretation. Here is a case of Kapila Hingorani versus State of Bihar, where private corporations, state-owned corporations failed to pay salary. Failing to pay salary is like depriving livelihood. So in this case, it is also violation of right to food. It is Article 47 on its own, which is talking about right to food, but then that was read with the right to life under Article 21, and court said that as a state, the state of Bihar was bound to provide for this salaries. So salary being connected to right to livelihood. Just now Dr. Bhatt was saying how grant in aid connected to right to legal education and connected to right to education, Article 21A. Because Human Development Index is associated with health, with education, livelihood, so this and legal rights also. So this is where it is coming in. Now you understand how directive principles of state policy could be in the back of the mind of the judges and making a difference. We had Paramanand Katara case. You know that some of these cases were the ones which were fundamental in bringing consumer law liability on doctors. So in this case, the refusal of treatment to a patient. So they said that government hospitals refusal. So that was interpreted in the context of government's duty to preserve life. So compensation was granted under the legislation in this case, even though it was a government hospital. Because the word service there is a free service, and a contract of service doesn't prevail. There is a charity. But still, the refusal of treatment is something that was taken as seriously as violation of right to preserve life. So right to preserve life is not there in right to life Article 21. It's a right to life according to the process of law and due procedure by the law. But right to life as a holistic right, irrespective of laws, direct intervention or not, comes from directive principles of state policy. See how the two are neatly aligned to weave a grand scheme of right to life with the numerable rights and unenumerated rights. Now, we also have seen judicial trends in Champakam Dorarajan case and Kerala State Education Bill case, where if there are conflict between right to education under Part 4 and state's power to make legislation to this regard, how Part 3 prevails, but not in conflict with Part 4, but in complementarity with Part 4. So look at the years of the decisions, 1951, 57 and Unni Krishnan case, where they said that the two are not exclusive to each other, they are complementary to each other. All these years are before right to education. So now the relationship between the two has been so concretized in terms of right to education. We have a separate Right to Education Act, which also has got nutrition and other dimensions from Part 4 taken into consideration in making policy. So fundamental rights are the means through which goals enumerated in Part 4 are achieved. So they set the goal, these are the means. And the realization, we say when we run an organization, the mission of the organization, and then the objectives and the activities. So the activities are the legislations and the policies that the state makes. So the governance of the state according to rule of law, and that rule of law coming from fundamental rights and directive principles of state policy. Today when we are talking about good governance, the good governance is the governance which is keeping all the stakeholders satisfied. If that satisfaction of stakeholders or good deliverance of service is to be achieved, then it has to be accordance with the rule of law. And the rule of law for governance is drawn from the Constitution. So for Constitution, the rule of law has got two prongs. It is fundamental rights as citizens, it's good governance as part 4. Therefore, relevance of governance in terms of part 4 emerges from the idea of compliance to the rule of law to achieve good governance. That is the overarching conclusion I would like to give. I'll draw your attention to Child Labour Prohibition and Regulation Act. Nowhere child was mentioned in the fundamental rights except special legislation shall be made for women and children. But regulating the labour in terms of child labour and having provisions in the Factories Act not to employ anyone under certain years of age, etc., came from directive principles of state policy. Similarly, Manrega came from directive principles of state policy, right to work, and nowadays this cow slaughter prohibition and cow slaughter aspects are coming a lot, and they connected it to organizing animal husbandry and agriculture. And there are many scientific data also which are coming into how, because of the introduction of artificial manure from the, have you read this? From the oil exporting countries, I mean like Middle East, we had a huge agreement during the Nehruvian and Mrs. Gandhi's regime, whereby urea was imported by our country to support their economy. And urea was used as a fertilizer. It in a way killed our soil quality, because till then Indian farming was developing itself based on the cow dung and other animal husbandry related manure. And today we are going back to that kind of thing because we did so much of ecological damage as well. So connecting it to agriculture and animal husbandry in terms of prohibition of slaughter of cows and bullocks, they gave a validation, not sanctity, validation from Article 48, but sanctity comes from Article 3. People's lifestyle, non-interference in the lifestyle, etc. Now, we also have a lot of host of labour legislation, including Maternity Benefit Act, etc. They are drawn from this. I have listed there even Consumer Protection Act, Equal Remuneration Act. And then we have a lot of government policies like Rural Development Program. We have had Tribal Development Program. We have a separate ministry for that. Pradhan Mantri Gram Sadak Yojana, because the minute you connect with roads, access to employment becomes easier and access to means of income easier, and also it improves access to hospitals. So both in living standard, quality of life and public health, the Gram Sadak Yojana has played a key role in many cases. Therefore, in terms of implementation, another overview if I can show you, establishment of Planning Commission, but working of the Planning Commission is criticized. Because if you see the allocation in last so many decades, the Northeast has not been much in the focus. Punjab has been given a lot of money. Most of the Planning Commission heads came from Punjab area. So these kinds of regionalism and petty Indian mentality is something that is a practical dimension, but in the policy it is very well enumerated and it is very well conceived when they made the Constitution. Minimum Wages Act, we told already, host of labour legislation. 73rd and 74th Amendment, decentralization. When I was starting my career, it came granting the Constitution to amend for realizing the Panchayat Raj. So in municipalities and panchayats, reservations came and allocations. But critique is that it can still be improved. There is a very minuscule of funding allotted. Lot of schemes are highly centralized still at the higher level of state ministry and taluka, etc. And then we have Criminal Procedure Code separating judiciary from executive in terms of public services. And then we had Environmental Protection Act and a constitutional amendment to develop the Right to Education Act. So with all that, we also have to remember, we already saw how judicial activism has infused life into part 4, and in implementing this, and they expedited the implementation of human rights compliance in terms of judiciary's case resolution. For example, compensating in Vishaka case they said that, Neelabati Behra they said that when state abuses its power. The idea of compensation came from the socio-economic rights under the socio-economic covenants. So instead of saying progressive realization, they immediately took recourse to these principles, our judiciary, and allocated remedies. In addition to punishment, compensatory jurisprudence came in conformity with the socio-economic and cultural rights of those people. The mother who loses her son due to police abuse and her economic survival in Neelabati Behra case, for example. Or somebody who is experiencing hostility as a woman and therefore being deprived and being given compensation in the Vishaka guidelines. So judiciary avoided the traditional distinction. It became more active to reach justice and with the broader dimension of infusing the ethos of part 4 into part 3. Now, some of the latest, with this government, I think the focus has come more, inspiration is drawn strongly from part 4, whether it is Stand Up India in terms of scheduled castes and others being encouraged to be entrepreneurs in the green fields, loans being applied, everything being available through the technical means of online Startup India approach, Samagra Shiksha, Rashtriya Gram Swaraj Abhiyan, Atal Bhujal Yojana, which is regarding groundwater management. And this is the first government which gave Jal Shakti Ministry, a water ministry, to be segregated from the environment ministry, and also Poshan Shakti, which is about nutrition. So some of this, I'll leave this presentation with you. You can make deeper analysis and generate some research or articles. So the last point I am talking to you about, my conclusion is that state, if it is very, very pulsating with people's ethos, like the current government, there may be certain political eccentricities, but then it is a government which is managed by people who are from the grassroots. There is no one who has entered the ministry unless they were in the cadre of the party. They grew through the ranks, even the current proposed presidential candidate. That means there is a little bit of empiricism in policy making, so they went through the route of directive principles of state policy. On the other hand, we also saw that courts don't have much of empiricism, and courts have, empiricism means ground reality. So courts have asked for expert social workers and researchers to support them with research. In environmental green courts, we have scientists on the panel. We have had in Buddhadev Karmaskar case and MC Mehta series and Sheila Barse case. I know MC Mehta, we have Sheila Barse on our visitors list. They have done empirical work as social workers. MC Mehta runs his own environment jurisprudence ashram in Dehradun. So they have gone and done the ground reality check, and they have filed public interest litigation to protect the rights of these people. And at that time, promptly courts have responded. So on their own, court cannot stretch its arm to do the empirical reality. At the trial level, we have court commission and other means. But at the Supreme Court level, once the decision has been given, whether in the appellate area or in the original area, we have seen in Buddhadev Karmaskar case how Justice Karju and Justice Gyansudha Mishra commissioned 2 NGOs to go and study the realities of sex workers, because by then Gaurav Jain case was talking about their children's pitiable conditions, and with all the data they issued instructions to governments, respective state government, which includes Mumbai, Calcutta, which are the feeders to this, but which are the receivers, but feeders come from everywhere, even Delhi. So here the deplorable condition of sex workers after their youth goes away, and their poverty and their illness, and what kind of measures can be taken by the respective state governments in making policy. Karnataka's Umashri took it seriously, and they made a huge allocation when Dr. Jayamala provided the report. So this is one instance of courts activism in realizing the principles of directive principles of state policy through mandating or instructing state. So wherever governance is weak, or wherever governance is not responding to the populist aspirations, courts have been active and hyperactive sometimes to remind the government to prioritize the policy areas. Wherever the government has been active, there you have seen that there is a co-regulation of welfarist approach using both part 3 and part 4 by these governments and by the court as well. So with that I conclude, I would say that a restricted view of the state action has been critically reviewed by the courts, and courts have reminded the function to the states through their judgments, as in case of Buddhadev Karmaskar, where the case was about awarding death punishment to somebody who murdered a sex worker in Calcutta. But court took a detour and it appointed these NGOs to do an analysis and then issued guidance. That is part 2 of the judgment. So we have had, you should study these things as resources, and then you should see, we call it as impact analysis of judicial pronouncements, how they have impacted subsequent policy formulation and judgment, and what kind of ethos have prompted the judges, where did they draw their power from, which part of the constitution or which provision of the constitution justifies such action. So you would necessarily see a kind of co-regulation of welfareism and common good by jointly reading part 3 and part 4. So with that I conclude. If you have any questions, 1 or 2 questions are welcome. Thank you very much. It has been 1 hour. I didn't think it will be 1 hour, and thank you for your cooperation. So here are my list of references. So I'll leave this PowerPoint with you as a resource. You all can read subsequently. I hope all the questions are clear. This is something you study as part of the curriculum, but I try to give a richer view by research. Thank you.